Good morning, good morning, good morning. How is everybody today? I guess everybody's still asleep. Hi, Judy. Hey, my name is Debbie. Welcome to my channel. We are on the closing argument of the Robert John Bardo trial. He unalived Rebecca Schaeffer in 1989 and was on trial. I forgot what was the trial 89 or the unaliving 89? I don't remember. I am very sleepy. I had insomnia last night, and I think it was like 3:30 by the time I went to bed. I am sleepy today.
You need to go outside? Come on.
Bradley.
Come on, go outside. You need to go pot.
Bradley Silberling is an American television and film director whose credits include the feature films Casper. I loved Casper. Actually, funny story. Well, not funny story. Weird story, maybe. I used to drink Coke all the time. I like Coke better than Pepsi. And when the movie Casper came out, at the time, I had two very, very close friends. And if I wasn't with one, I was with the other one. And they both drank Pepsi. And I go to their house, and they were like, "You want something to drink?" And I was like, "Yeah, I want a Coke." And they were like, "We don't have Coke, we don't have Pepsi." So I would drink Pepsi at their house. And I started liking it better than Coke. And then about that time, Casper came out. And there was the cutest little commercial where Casper would stick his head in the side of the fridge, and he saw the Pepsi. And then he'd stick his hand through the side of the fridge, and he'd grab the Pepsi, and he'd go to pull it out, and it wouldn't come out of the fridge just because it was solid. And so, because of that commercial, I started drinking Pepsi. Not only that, but my two friends. But if his hand goes through the fridge, why didn't his hand go through the Pepsi? Y'all, I am running on almost no sleep. Okay. Casper, City of Angels, Moonlight Mile, Lemony Snicket's A Series of Unfortunate Events. Was that the Jim Carrey one? Yes, because Jim Carrey was the movie one. And then Neil Patrick Harris was the one in the miniseries that was on Netflix. So the movie, Lemony Snicket's A Series of Unfortunate Events, Jim Carrey. I've not seen City of Angels or Moonlight Mile. Cool. And why are we talking about Bradley Silberling? Because mystery solved. He is the man always in the front row with the long dark hair and glasses. He was Rebecca's boyfriend at the time of the incident. He is now married to Amy Brennan, and that name sounds familiar. Why does that name sound familiar, Judy? Who is Amy Brennan? Amy Frederica. Oh, no, that's not the right person. That says Brenneman. I didn't ask for Brenneman. I asked for Brennan. What are you doing, Google? Give me what I asked for, Google. Oh, that is her. Okay. Never seen any of these movies. Sweet Girl, Tell Me Your Secrets, God's Foster Boy, Her Mind in Pieces, Peel, Monster Challenge, Jane the Virgin, Here Now, The Get, The Leftovers. I've heard of some of the TV shows. No Tomorrow and the Shadows of the Rainbow. Yeah, I know who she is. Yeah, I don't know who she is. Ugh. I'm not sleepy. I'm just goofy because I didn't get enough sleep. It's okay. It's okay. It happens. Not to me, what? He just jumps in and says, not to me. No good morning, no hi Debbie, no hugs, no nothing, just not to me. Okay. But he hugs Judy. Okay. Sure, Marty. All right. Thank you for reminding me that the network is good. I think I already knew that phone. Oh. Well, the name Amy Brennan sounded familiar, and that wasn't even the right name, so I'm just stupid, I guess.
Defendant is present, both counsel. Ready to proceed?
Yes, Your Honor.
You wish to make an opening argument?
Closing statements. Closing argument.
Waive opening argument.
Right, Mr. Galindo?
Yes. Your Honor, I'd like to start out by saying and acknowledging that Rebecca Schaeffer is a victim in the true sense of the word. There's no doubt about that. She did nothing to deserve the fate that befell her. I would like to suggest that Robert Bardo, too, is a victim, although not to the degree, of course, that Rebecca Schaeffer suffered as a victim. But nevertheless, I think it's important to point out, or I feel compelled to point out, that in my opinion, he is a victim of parental neglect. He was a victim of a mental health system which was powerless to provide the type of help that he needed, and which he clearly needed, and which they attempted to do. I also feel compelled to point out that, in my opinion, he was a victim of a justice system which failed to provide his attorney the needed psychiatric or funds to retain a psychiatric expert in time, other than 16 days prior to his testimony was to begin in this case. I want to thank you, Judge, for providing the resources which enabled me to retain psychiatrists in this case. And by so doing, you prevented a serious travesty of justice. And on behalf of Robert and myself, I do want to thank you for that. But nevertheless, due to the way that it occurred, it has now rendered my psychiatrist susceptible of criticism for reaching an opinion based on an interview which occurred 2 years after the fact, and which you yourself have pointed out has raised suspicion on the reliability of the comments made to Dr. Dietz by Robert. Nevertheless, I would ask the court to focus in on what I think is the main issue in this case. And that is, when Robert Bardo formed the intent to kill Rebecca Schaeffer, which we concede he did, was it done under circumstances as defined by our legal fiction of lying in wait? And I suggest to you, with all due respect, that he did not. Lying in wait is not appropriate in this case. The legal fiction of lying in wait does not exist in this case because Robert Bardo formed the intent to kill at the time he perceived Rebecca Schaeffer to be arrogant, as he used that term, and at the time he perceived Rebecca Schaeffer to be annoyed with him as she approached him on the second visit. If that theory is embraced, or if there is a reasonable doubt as to whether or not that statement of facts does exist, he would clearly be entitled to an acquittal of the lying in wait allegation. I say that there was no lying in wait because there was no concealment of purpose under that theory of facts. There would be no concealment of purpose because at the time he approached Rebecca Schaeffer's door, this on the second visit, he had no purpose to injure or to hurt her or to kill her. If believed, his intent, his purpose, if you will, was to speak to her some more, was to give her a letter. And I will address the court's concerns about whether or not that's a fair statement of the evidence. But clearly, if he did not have the purpose of injuring or killing Rebecca Schaeffer when he approached on that second visit, he would not be guilty of lying in wait. Furthermore, he would not be guilty of lying in wait because he had no substantial period of waiting and watching prior to the second visit. After the first visit, and I'll concede that all of those things which occurred prior to the first visit would be justification to assume there was waiting and watching, and a substantial period of waiting and watching. The letter to Arlene, the purchase of the gun, the statements to the niece, all of those things would be construed, could be construed as a substantial period of waiting and watching. However, after the first visit, if he's to be believed, all of the intent to injure, the intent to kill, all of those preparations which we have conceded would amount to waiting and watching vanished. And therein, from the second visit, there was no substantial period of waiting and watching. There was no waiting and watching with the intent to inflict injury. There was no waiting and watching to take Rebecca Schaeffer by surprise. There was no waiting and watching for an opportune time to act. Furthermore, within our legal fiction and definition of lying in wait, the attack would have to occur immediately from the period of waiting and watching. We would have to say that the people have proven beyond a reasonable doubt that the lethal acts did flow continuously from the period of waiting and watching.
Hey, Jennifer!
That there was no cognizable interruption between the waiting and watching and the lethal acts. Clearly, Your Honor, if Robert's statements or the defense position is valid regarding his lack of intent to injure upon approaching on the second time, there would be a cognizable interruption between the waiting and watching, and there would be no substantial period of waiting and watching. Now, I think the next step logically has to be then, does the evidence objectively establish a reasonable doubt as to whether or not this defense theory is true? And I agree with you. You cannot split open the cranium of an individual and look inside for the answer. And unfortunately, we do not have a videotape of his actions immediately prior to the lethal acts. So we have to do the next best thing. And that is, let's look at the evidence objectively for any corroboration of this version of facts. And I say that there is some. I will start with Dr. Dietz' testimony. And I might add that this is uncontroverted psychiatric evidence. There's no psychiatrist that came before this court to state that Dr. Dietz' opinion was unreasonable or unfounded. His testimony stands alone. You have to ask yourself, is he credible? Is he reliable? Well, I can stand here and tell you, Your Honor, that here's a psychiatrist The only psychiatrist in the United States, or in the world for that matter, as far as I know, who has ever done a study specifically looking at people such as Robert Bardo, who have written letters, people who have been categorized as obsessed fans. He did this for the Department of Justice. That should give him some credibility. The fact that he lectures for the FBI, the CIA, the fact that he has counseled the Los Angeles Police Department on this issue, on this area, that to me smacks of some strong credibility. I cannot believe that the court would consider for a moment of buying the DA's argument that he reached a favorable opinion for the defense in this case because he was interested in the publicity. I think that position is ludicrous, especially in light of his testimony that he has turned down ample opportunities at publicity on a national level through all those various shows, Donahue Show, Geraldo, and so on. I don't think that's a fair conclusion, and I don't think that's a fair basis to reject his opinion, if you're so inclined. When I look at all of the evidence objectively, I believe it supports his opinion that Robert Bardo suffered from a mental disorder. Of that, he had no doubt. And his opinion was clear that that mental disorder impacted on Robert's ability to form the intent to kill, and it impacted on when he formed the intent to kill. Now, I'll concede, so we don't get boggled down on these other points, that because of the mental disorder, that did not prevent Robert Bardo from having the capacity to form the intent to kill, or from Robert Bardo, it's clear, suffered from extreme vacillations of emotions, contradictory emotions held simultaneously. And as Dr. Dietz stated, it was like a toggle switch, flipping between the two emotions simultaneously. This mental state, this condition of Robert Bardo is what separates this case vis-a-vis the lying in wait theory from all other cases that the court has read and considered. In all of those lying in wait cases, the Ward case, the Sassoonian case, all of the cases, none of those cases involved a person who had a vacillation of emotions, such as we have here in the case of Robert Bardo. This is a unique case of first impression, and this is why factual comparisons between those other cases and this case do not hold true. In this case, there was no singularity of purpose, there was no singularity of intent, and we had that, or the courts found that in all other cases defining lying in wait. In my opinion, the uncontroverted, unrebutted testimony of Dr. Dietz on this issue alone raises a reasonable doubt as to whether or not Robert Bardo had the required mental state which is necessary for lying in wait. Along with that, we had the further corroboration of the letter written by Robert to Mr. Cleaves, wherein he states that after the first visit, all his negative feelings vanished. That when he went back to Rebecca Schaeffer's apartment the second time, it was with the intent only of meeting her further, speaking to her further, and giving her a letter. Clearly it believed this would negate the inference that he had the required mental state for lying in wait. Now, I know what you're going to say, Your Honor. As you pointed out, at the 1118 motion, you said we cannot rely on the Cleaves letter, and presumably we cannot rely on Dr. Dietz's evaluation, no matter how honest and forthright, because the evaluation of Dr. Dietz occurred 2 years later, and he evaluated. It was rhetorical, Your Honor.
But I said absolutely nothing about Dr. Dietz's opinion or whether we could or could not rely on it at the time of the 1118 motion. Dr. Dietz had not testified.
Your Honor, it's rhetorical, and I was referring to the Cleaves letter, and I'm sorry if I misspoke or misunderstood.
The Cleaves letter was not introduced for the truth of the matter asserted. It was introduced as a foundation that Dr. Dietz could testify to.
I understand.
And I said you can't use it for the truth of the matter asserted. you still can't use it for the truth of the matter asserted.
What I'm getting at, Your Honor, is that Dr. Dietz' opinion and the Cleves letter are susceptible of the attack, as you pointed out in the 1118 ruling, that Robert knew of the defense theory because he went to the preliminary hearing and he went to the defense. He was present during our motion to dismiss pursuant to 995 of the Penal Code. And I believe you said in ruling on the 1118 motion that if that letter had been written immediately after the arrest, then presumably it would be entitled to more weight. And I'm paraphrasing.
No, I said that I would have to reanalyze.
What I'm indicating to the court is that we do have that corroboration, because immediately after his arrest in Tucson, Arizona, he was interviewed by the Tucson Police Department and by these two officers of the Los Angeles Police Department. And those two statements, which I'm sure the district attorney is going to state are accurate, at least as far as reported by the police, reiterates and corroborates everything that the defense has been putting forth. And it corroborates Dr. Dietz's opinion and the basis for his opinion. Now, I would remind the court that during that period of time, on the date of his arrest, which I believe was July 19th, 1989, there was no theory of lying in wait put forth on this case. It hadn't even been filed, it hadn't even been considered as far as I know. But what do we have? We have the officers indicating exactly what Dr. Dietz said, and that was that Robert Bardo stated originally his intent was to kill Rebecca Schaeffer because he was annoyed with his perceived portrayal of her innocence, her image of innocence. And he said, there was confusion in my mind. I wanted to hurt her, but then I didn't want to hurt her. At first, I wanted to shoot her. He goes on, when I went to Rebecca's, I planned to wait for her and shoot her as she came out or went in. This is directly corroborating Dietz's opinion and analysis. But he goes on to say, but after I met her, she was a normal person, like a college student, and I was happy. This corroborates the theory of the defense that was put forth in the Cleves letter that Dr. Dietz relied upon in interviewing Mr. Bardo, that this was a man of conflicting, vacillating emotions. So yes, he did have the intent originally, but it vanished after the first meeting. And I take issue with the fact that Robert Bardo considered the first meeting as a rejection of him somehow, because nowhere in his statements to the police does he ever state that. He only states or relates or explains the first meeting as being a positive meeting, one where he was, as he says here, happy. In fact, even in the Tucson interview, which was tape recorded and which the court tried to discern, I know firsthand, but luckily we had the transcript, it is expressly stated there, time and time again, and again before lying in wait was ever a theory in contention, he states on the first visit that she calmed me down, that I was happy that she was a normal person, that originally he thought and was expecting this larger-than-life person, but that she wasn't that way. She was just a normal person. He kept reiterating that over and over again, that she was normal, she was regular, she wasn't pretentious, she wasn't arrogant. He was happy. It was a positive encounter. So I'm submitting, Your Honor, that when he left after that first visit, all of the evidence which the prosecution, which the government states is indicative of lying in wait, all of those, the letters, the encounters with the people on the street, at that point in time, there was a break in the sequence. There was a break.
This is a defense attorney, right? This is a defense. He's reading letters of how... Never mind. I'm being sarcastic, but yes, this is a defense attorney.
In the waiting and watching and the lethal acts, it vanished. And if you don't accept that, at least I think there is a reasonable doubt as to whether or not that occurred, because it's from the people's own evidence, witnesses from the police themselves that occurred at the time of the arrest, which gives it credibility and which corroborates. So we don't need necessarily Dr. Dietz' testimony to be looked at unilaterally. I'm asking the court to look at all of the evidence in reaching this conclusion. And there is some strong reasonable doubt in my mind on that issue. And I think the court would agree that if it's true that Robert Bardo's negative feelings vanished after the first meeting, and when he left and went away for that hour period of time or so, if the court accepts that, then there would not be lying in wait as defined by the case law. Now, the court made reference to the hard evidence at the 1118 motion, the hard evidence being Lynn Marta's testimony. But luckily, we had a chance to expand on that bit of evidence. We had the reconstruction, Your Honor, of the event in question. And I think what the government is asking you to do is to make inferences and assumptions which would negate the concept that Robert Bardo had that conversation, as he described it, with Rebecca Schaeffer on the second visit. Now, the conversation, as he described it, was not a conversation of great length and magnitude. But nevertheless, I believe the conclusion the court was being asked to reach was that if Lynn Marta did not hear the conversation, it therefore did not exist, and Robert Bardo is lying. But I would point out to the court that during our experiments, our reenactment, it was absolutely clear that you could hear not only voices and steps, but you could hear the latch turning, and you could clearly hear the door opening. If we are to take the Clarkian logic to that point, what we're going to have to assume then is that because Lynn Marta did not hear the door latch turn and did not hear the door open, therefore it must mean that the door did not open, and we know that's false. I think what is a reasonable interpretation from the evidence is that, unlike the investigators during the reenactment, whose attention was focused primarily on what they could hear, I think Lynn Marta was not focusing her attention on what she could hear. She wasn't trying to hear voices. She wasn't trying to hear the door latch opening. She wasn't trying to hear the door open. And she admits that freely in her testimony. And why should she? This was, as far as she knew, just a normal day in her life where people presumably open the door, walk back and forth, as they do, I assume, on many other occasions. But we have a clue as to why her attention was not focused on that. And she says that she paralleled the steps of Rebecca Schaeffer when she heard the buzzer ring, but paralleled it, Your Honor, not all the way to the front door, as we've now shown, but for a period of about 9 feet. She reached the door to her apartment and was going to go out to talk to her and explain to Rebecca that she had thrown away all these newspapers and whatnot. But then, as she testified at the preliminary hearing, her attention was diverted to her cat meowing. Her cat wanted to be fed, and the cat continued to meow and to demand to be fed during this period of time, and in sufficient manner so that Lynn Marta's attention and focus were diverted. And she then turned towards the cat, began to walk into the kitchen. I don't know if Your Honor has cats or not. You talked about, okay, well then you know. Then you know how persistent a cat can be when they want to be fed, presumably. In any event, we know that Lynn Marta testified to that. And we know that her attention was not focused on trying to hear doors open or trying to hear voices. So I submit that her lack of hearing any voices does not, ergo, mean that Robert Bardo's statement is false, that there was not some conversation. That brings me to the next point of what you've described as hard evidence, and that is the coroner's testimony concerning the 75-degree bullet angle. I believe during the trial, during your questioning of Dr. Dietz on that issue, you posed a hypothetical or a version of facts that might have been possible. And that is that let's assume that Rebecca Schaeffer came down the steps and opened the door and bent forward looking for scripts or paper or something along those lines. And let's assume that Robert Bardo was hiding in the bushes, jumped out, and then shot her while she was bending down. That could explain the physical evidence of the 75-degree angle. And I'm not conceding that that 75-degree angle is deserving of a lot of credibility because of the nature of the path and the depth of the path, I think, leaves some question as to that. But that's fine. That's a reasonable inference, and I don't take issue with the court in drawing that interpretation. But how about drawing some interpretations for the defense, Your Honor? Because I think it's just as reasonable, in the light of any evidence to the contrary, to assume then that Robert Bardo was telling the truth, that the defense theory is true, that when Rebecca Schaeffer came down, and she could see at that close distance that he was there, that she opened the door, but that when he became angry and perhaps said, "Here, bitch, I'm going to give you this," maybe she became fearful. Maybe she recoiled, and in recoiling, bent down somewhat slightly. And that would explain, just as your other version would explain, the trajectory path of the bullet. I think it's only fair that if we're going to speculate and pull out inferences upon inferences, that we do so on both sides. And it's important because, as you know, Your Honor, that if there are two reasonable interpretations or more, one of which leads to the conclusion that the defendant is innocent on any particular point, the law mandates that we accept that interpretation. And I could go on. I think there are a number of inferences and speculations that could be drawn as to the physical evidence. But I think it's sufficient to make my point, that if there is at least one, and I'm sure that you, Your Honor, can come up with a lot more on that issue, that there are several that could be raised that would be consistent with the defense position. There are several issues that have been raised in this case, and the cross-examination of Dr. Dietz was extensive. And yes, you can point to one piece of evidence in isolation, a letter or a statement, and in isolation we can say, yes, that appears to be normal. But I think it's clear to everyone, Your Honor, that Robert Bardo was not normal as far as the mental state is concerned on these legal issues. I think Dr. Dietz's testimony was very accurate. I think he's credible, he's reliable, and I stand behind Dr. Dietz on that. As he told this court, when I first attempted to retain him, 16 days, or actually about sometime prior to that, before he got any materials, he told me then, you better make sure you have another psychiatrist, because based on what I know, I don't think I can help you. And he testified to that under oath. Now I'd ask the court to consider that as well as all of the other evidence. These facts, Your Honor, are unique. This is a case of first impression as far as the lying in wait legal fiction is concerned. No other cases dealt with an individual such as Robert Bardo, who had this mental disorder, this vacillation of intent, this vacillation of emotions, the simultaneously held emotions. I concede Robert Bardo, at the time he fired the shot, did have the intent to kill. That's clear. But I can stand here before you, Your Honor, without any hesitation and tell you that based on this trial, based on all the evidence that's been presented, Robert Bardo is not guilty of lying in wait for the reasons I put forth. His biggest problem and his biggest mistake was that he chose an individual who was famous, and that's why we have all of this. And that's going to be his undoing. It's unfortunate.
Just a moment, Mr. Glenn. What do you mean all of this is going to be his undoing? I would really like you to elaborate on that.
By that I mean that it is my opinion that cameras in the courtroom are never good for the defense.
Mr. Galindo, you were given the opportunity to object. You did not.
That's not true. I did object in
You
chambers.
said, well, I really don't like them, but I suppose something to the effect that it's the modern thing or something like that.
I take issue, Your Honor, and I will, and let me remind you, when we were in chambers, you asked me if I objected, and I said I do object. And I believe your statement was there was no legal basis for which to not allow the cameras.
No, sir.
Okay,
Your
well,
recollection is totally in error.
fine. Well, then if that's going to
You
be,
said you didn't like cameras, but something to the effect that they were inevitable.
fine, then we should put
At
it,
any rate, how are these cameras going to affect your client on the issue of guilt or innocence?
you know, I'm going to withdraw the statement because what's happening here is
Better,
we're
Mr.
getting
Galindo, unless you
into,
can utter also a reason for it. You're implying that this court would rule differently
No.
if there were no cameras. Then what
No.
are you talking about?
well, now you're making an issue of this, and now I'm going to have.
No, you made an issue of it. You said that these, in fact, I'm going to invite the court reporter to read the remark.
I know what I said, Your Honor. I
I
said
don't
that
know
it's his undoing.
what you said, and I want to quote it exactly.
Okay.
Would you please read the remark that he made about the cameras?
His biggest problem and his biggest mistake was that he chose an individual who was famous, and that's why we have all of this, and that's going to be his own doing.
So it is what?
His own doing.
Undoing.
Undoing.
I still don't understand what you mean by
Well,
that.
let me just,
And if you want me to consider your argument and your reasoning, you should explain it so that I can understand it.
well, I already indicated I'll withdraw that portion, and I do. But let me state this. If the court drew an inference such as you stated, then I apologize for that and tell you that that's not what I meant.
I don't want to draw that inference, but I can't think of any other reasonable interpretation to give to it.
Well,
So
that's not what I
I'm
meant.
inviting you to give another reasonable interpretation.
Then I will. What I'm telling you is that I don't like cameras in the courtroom. I think it impacts adversely on a client. I've maintained that position. I maintain it here before you now, and I will always maintain that as far as I can tell. Now, if the court feels that I made that improper inference, then I apologize. And I'm telling you now,
You're right.
on the record, that I didn't mean that. But I am stating,
Let's
I don't
proceed then. I'll
want.
take your word for it.
Thank you. In any event, given the circumstances such as they are, I feel that the evidence is insufficient to establish that he
Don't argue with the dead.
had the mental state that was necessary for lying in wait, that the evidence is more than sufficient to raise a reasonable doubt as to whether or not, when he went back that second time, he had the intent to kill, and that the medical corroboration, the uncontroverted psychiatric testimony of Dr. Dietz corroborates that theory. I'm telling you that it's my position, whether you agree with me or not, that a fair reading of this evidence, an objective reading of this evidence, in my opinion, is that Robert Bardo is not guilty of first-degree murder, is not guilty of having committed that murder while lying in wait, and is guilty only of second-degree murder because he had an intent to kill at a time when he did not premeditate and deliberate. So with that, I'm finished, and of course, I will be happy to answer any of the questions or concerns that you may have concerning my interpretation of the evidence.
All right, I'm going to take a very short recess, and because I interrupted you, and perhaps might have been a little bit sensitive to what you were saying, I'm going to give you an opportunity to continue beyond that. Okay? We'll be in recess for 10 minutes.
Oh, we might get through this today.
In newspaper articles and magazines. Well, if Dr. Dietz was so publicity shy, then how did this defendant happen to hear from him through the media? Obviously, we do not have a clear picture of Dr. Dietz if we consider him to be a publicity shy, shrinking wallflower. That is simply not the case, and this defendant knew it. And we don't know. One thing that was not probed by counsel is why he turned down the publicity opportunities that he did. There may be multitude of reasons for that, none of which may deal with the fact that he is just a self-serving humanitarian. We don't know what the reasons are, and I won't speculate, but I will simply point out the lack of information in that regard. In general, I was very troubled by the fact that the doctor frequently gave answers on direct examination that presented only the exculpatory or the sympathetic or more psychiatrically disturbed explanation. Only on cross-examination or in response to the court's questioning did he admit that there were explanations less favorable to the defense that were also plausible. And not just equally so, Your Honor, but more so. Thus, for example, while on direct examination, the doctor endorsed the defendant's excuse that he was protecting his brother Ed in lying to the police concerning the defendant and his family. But only on cross-examination did we discover that at least in one case, those statements were made by a program administrator who never even met the defendant, and in another, that the people Dr. Dietz referred to as hospital staff not only were not hospital staff, indeed, he had no idea who one of them was at all, although he knew the other one was certainly not a member of the staff of the hospital, was a social worker. But he also had no idea whether they themselves had ever even met the defendant's family. Thus, not only did he fail to reveal the true nature of his source of information, but he directly misrepresented those sources on direct examination. Unfortunately, these examples are not isolated instances at all, but are part of the overall pattern of the testimony given by Dr. Dietz during direct examination. So in discussing the defendant's school letters, Dr. Dietz pulled lines wholly out of context to create an apparency of wildly psychotic thinking that, when put back into context and subjected to dispassionate analysis, appeared to be considerably less psychiatrically significant. Now, I'm referring at this point, Your Honor, to the letter dated January 26, 1984, that the defendant wrote to his counselor, Dr. Don Hickman. And that was a letter in which the doctor found evidence of delusion, loose association, and generally psychotic thinking. When this topic was probed on cross-examination, the doctor conceded that when these statements were examined with alternate explanations in mind, they might not be seen as evidence of psychosis. And he retreated to the statement that yet these writings were, quote unquote, not normal for a 13-year-old boy. Well, I don't take issue with the stance that this defendant was not a normal 13-year-old, nor with the notion that he was not a normal 19-year-old. A normal person doesn't stalk and murder a celebrity he's never met. Nor does a normal person, by the way, attempt to assassinate a president to secure the admiration of an actress. But that's a far cry from giving the most florid and severe psychiatric diagnosis one can find, that of schizophrenia. And it's a far cry from the diagnosis he rendered for the government in the Hinckley case, in which he concluded that the defendant there suffered from personality disorders of far less magnitude and severity than schizophrenia. And although on redirect, the doctor admitted there was room for skepticism concerning the defendant's claim to have had auditory hallucinations in the past, we heard none of that skepticism during his direct examination testimony. In fact, he stated that he checked for malingering, but found no evidence of that during his direct examination. And yet there was room for doubt that this doctor left largely, if not completely, unexplored. Consider the fact that Dr. Mayer heard the defendant's complaint of auditory hallucination in 1984, yet diagnosed him as having depressive dysthymic disorder. This is a neuroses. This is sad mood disorder. This is not psychotic. And I might note, parenthetically, Your Honor, it's of some interest, that was the primary diagnosis that Dr. Dietz gave to John Hinckley when he testified for the government in that case. The fact that other than the one mentioned 2 days after his release from Palos Verdes Hospital, there is no mention of voices by this defendant of hearing voices in any of his school letters. He's released from Palo Verde Hospital. 2 days later, he writes of voices telling him to kill. Either in that letter or 1 day later, he writes that he is studying psychology, and then never again do we hear about voices until he's in the hospital in Tucson Psychiatric Institute. Now, if he indeed had been hearing voices, and obviously was not afraid to say it once in the letters, he surely would have said it again if it were true, but he did not. The fact that when he was initially admitted to Tucson Psychiatric Hospital, he complained of voices telling him to kill his nieces and to run away from his foster home. But very shortly after his admission, interestingly enough, he confessed that he would never hurt his nieces, and he coincidentally was not happy in his foster home anyway. And the fact that he reported a visual hallucination that did not comport with the kind of visual hallucinations typically reported by schizophrenics, and that there was no organic disorder that would explain it. And the fact that there is no further mention of voices by this defendant in any of his writings after his stay in Tucson Psychiatric Institute until he was incarcerated for murder. Additionally, The possibility of this defendant being eminently suggestible as a young boy thirsty for attention was acknowledged by Dr. Dietz, but apparently never raised in his clinical interview with the defendant. Nor did the doctor ever even bother to pick up a phone to discuss these multiple reasons for doubting an important facet of his diagnosis with the doctors who treated the defendant back in '84 and '85. All of these reasons exist, Your Honor, and were there for the doctor to probe, to examine the possibility of malingering, to examine the possibility of manipulation, to examine the possibility that this defendant was simply seeking attention that he desperately craved. It was given no hint of exploration by the doctor in any of his discussion during either direct or cross-examination. And I can't speak for the court, but I can say that I am not impressed with the excuse of having too little time to do his homework properly. If that was the case, then he should have refused the appointment, not taken the stand to render conclusions so thinly supported and inadequately investigated. And when we come to the point of his conclusions concerning the defendant's present mental state at the time of the crime, the doctor's opinions, unfortunately, fare no better. On direct examination, he stated that the defendant held a bouquet of delusional thoughts and beliefs concerning Rebecca Schaeffer. On cross-examination, I attempted to pin down what he referred to. And I found myself chasing wisps of smoke and trying to grab at shadows, because in truth, there was nothing delusional there at all. Instead, what only became clear on cross-examination is that the defendant was indeed obsessed with Rebecca Schaeffer. There's no doubt of that. But he held no delusions about what she thought of him. Indeed, he realistically told Dr. Dietz that he felt she never even knew about him. And that feeling was certainly apparent in his letters if one simply chooses to look at them objectively. Although he wrote approximately 40 letters, he opened every one of them with a description of who he was. This is an obvious indication that the defendant did not expect Rebecca Schaeffer to remember or even know of him. That's one point. Secondly, he referred to himself as her quote-unquote fan, or again in other places as just a fan. Thirdly, he offered it as a distinct possibility that she threw his letters away and did not care because he was just a fan, quote-unquote. He wrote of his rather realistic fear that she did not even read his letters herself, and that she was probably too busy to write back to him. Despite these clear and unequivocal statements demonstrating his realistic thinking about what he could expect from Rebecca Schaeffer at a point in time before there was motive to lie or embellish, the doctor chose instead to place reliance on statements made long after the murder. And so, based on letters to Robert Cleves, written at least a year, if not 2 years after the murder, and his conversation with the defendant more than 2 years after the murder, Dr. Dietz concluded that the defendant expected, as well as hoped, that he would one day date Rebecca Schaeffer. Now, these romantic notions, Your Honor, are not expressed overtly in any pre-offense writings. And that's an important point that received very little attention from Dr. Dietz. Because while this does not mean that the defendant may not have had such dreams, what it does mean is that even the defendant did not consciously entertain them as a realistic goal to the extent that he would write about them. And the importance of that is, as even Dr. Dietz admitted on cross-examination, that the defendant harbored no delusions about what Rebecca Schaeffer felt for him. Well, if that's so, Your Honor, as a practical matter, then where is the evidence of delusion? That the defendant deluded himself into believing that maybe someday Rebecca might be his friend? Well, then haven't we all been guilty of being delusional at some point in our lives? Have we not all held some unrealistic hope or dream? This just shows that the defendant had high hopes, albeit perhaps unrealistic. I'm not even sure that I can say that. Because if all he dreamed or hoped of was that she would write back to him someday, is that so unrealistic? She did once. So we might conclude that the defendant was a dreamer. But as the doctor admitted, he testified in the Hinckley case, having hopes and dreams does not mean one has a serious mental disorder. And that's really what the evidence reveals about this defendant's obsession with Rebecca Schaeffer. Not that he held any bouquets, delusional or otherwise, merely that he unrealistically hoped and dreamed for some response from her, some connection, be it as a fan or a friend. He did not hold any belief about her feelings for him. That was unrealistic at all, and quite the contrary. And that's the problem with that statement about the defendant's delusional thinking. It's simply not borne out in the evidence. Hopes and dreams, possibly. Delusions, I see none. The same problem arose with the doctor's opinion about the defendant supposedly showing symptoms of referential thinking. His most sensational basis for that conclusion was the statement the defendant supposedly made about feeling responsible for Samantha Smith's death by reading her postcard. I find it very interesting that the doctor's notes reveal no such quotation by the defendant. In fact, all we can find in these copious notes that are otherwise replete with quotations from the defendant is a statement that he read her postcard on the day she died. That statement sounds more like an observation of coincidence than it does referential thinking. And as the doctor said, observations of coincidence do not qualify as referential thinking. But he insisted that such a statement was made during the mental symptom check that is not contained anywhere in his notes or on videotape. Now, if indeed the defendant ever made such a statement, one might question its credibility if one were of a mind to do so in light of the fact that it may have been made in response to a leading and suggestive question that allowed the defendant to adopt a psychiatrically significant symptom by simply saying, yes, I thought that. And in light of the fact that the defendant's unassisted statements that appear later on in the doctor's notes do not repeat that thought, and in light of the fact that he never wrote of those feelings in his school letters or anywhere else, leads one to conclude that the doctor should at least have questioned the authenticity of that symptom. And in light of the fact, further, Your Honor, that the doctor himself acknowledged that suggestiveness and leading questions and suggestive and leading questions by a psychiatrist posed to a patient, particularly in the forensic arena, can certainly create responses that are untrue because he is trying to please the doctor and appear to fit the diagnosis that he thinks will benefit him. In such a case as this one, where the doctor is clearly trying to find some evidence of psychosis with respect to the defendant's relationship to celebrities, and he asks the defendant, well, in reading the postcard, did you feel that you had caused Samantha Smith's death? I submit to you, Your Honor, that a defendant of much lesser intellectual capabilities than this defendant would have said, of course, I'm supposed to say yes. And then, unfortunately, in the unassisted statements later on in the notes, he fails to repeat that statement, simply because it was not truly held. Now, although this is interesting, the doctor was very quick to point out that one should not premise a diagnosis on one isolated instance of conduct that could be just a hospital's charting error. I believe that was the excuse he gave for the visual hallucination. I found no effort to be equally as cautious in his own work with this example of Samantha Smith in diagnosing this defendant. In light of the contraindicating facts I've just pointed out, why was Dr. Dietz not skeptical of that one isolated response given by this defendant under at least potentially suggestive and leading circumstances? But not only was he not so cautious, he pointed to it as epitomizing the defendant's symptom of referential thinking, despite the fact that he had ample cause to doubt its authenticity. If we eliminate that basis, all we have left are the songs, and this was the thinnest ice he skated on of all. When pressed to explain what he found to indicate referential thinking in this area, each example literally fell apart. The bottom line was that Dr. Dietz felt the defendant found these songs to be simply too significant. I think it was at some point the doctor said, it's not just that he thinks the songs are apropos, it's more than that. What? What is it? What's more than that? What is it, doctor? In your opinion, you think he found these songs too significant? And how is that evidence of referential thinking? That was never shown. And that was never shown because it is not true. Finding a song very significant, believing a song relates to you or something you felt in your life is not evidence of psychosis. And it is not evidence of delusional or referential thinking. These songs, as I could determine from the doctor's testimony, impelled this defendant to do nothing. Rather, he found it comforting to listen to them when he felt animosity for Rebecca Schaeffer. He said he could relate to the lyrics. How many millions of teenagers would say this? And millions, Your Honor, would not be an exaggeration in this case. It's a very popular song. Certainly there is nothing of psychiatric significance in the defendant's affinity for these songs. That he reads his own meaning into these songs and was able to relate them to his feelings for Rebecca Schaeffer is certainly further evidence of his obsession. But to say that this points to referential thinking, or that this amounts to referential thinking, strains the meaning and definition of that term far beyond its intended use. And I think a further point needs to be made on this area. The bottom line about these songs that the defendant found significant or that he could relate to is that he chose them. Who chose these songs? I pose this question to Dr. Dietz. Who chose the Joshua Tree tape? Who chose Exit? Who chose With or Without You? On each occasion, the doctor said the defendant did. Did voices compel him to do so, I asked? No. The defendant chose to do that on his own. The defendant chose these songs because he had an affinity for them like all the rest of us do. So in the final analysis, when each leg supporting the opinions of Dr. Dietz is objectively tested, each one collapses under the weight of scrutiny, and the conclusion that rests thereon collapses with them. Now we're left with only this notion of ambivalence, which he used to give rather devastatingly inculpatory evidence and exonerating topspin. And so when the defendant spoke of his aborted plan to kill Rebecca Schaeffer with a knife when he went to see her in July of 1987, the doctor told the defendant the story of Ralph Now, in whose conduct he found a similar example of ambivalence. Unfortunately, the example he gave simply did not occur as he described it, and the event he purportedly relied upon differed in every material respect from the incident he compared it to in this case. He testified that Ralph Now stood outside and inexplicably went in when the celebrity was about to appear. He conceded later on, well, yes, I guess he was just standing on line with everyone else and went in when they did. And then he says he was sitting in the concert hall waiting for the celebrity to appear on stage, and just before she did, he inexplicably went to get a drink because he had an inexplicable thirst. In fact, that wasn't what occurred at all. What occurred was the celebrity took the stage. Ralph Now got up, approached the stage, was escorted back to his seat by Gavin DeBecker's security personnel, and they watched him as he sat in his seat and watched her perform for 10 minutes before they escorted him, they didn't escort him. He got up and left the building completely, not to get a drink or do anything else. And later we find out it's because he felt it had to be an imposter. It was not the real celebrity. He was not armed, and he did not intend to hurt her at that concert. Now, how does that bear any relationship at all to the incident described by this defendant, where he claims to have gone in July of 1987 armed with a knife and a plan to do to Rebecca Schaeffer what Arthur Jackson did to Teresa Saldana, because he felt great animosity after having been thrown off the Burbank Studios lot in June of 1987, and that after waiting for hours outside the soundstage and the red light going off, he says, I just had this inexplicable thirst as he was waiting for her, and just at the point when he would be likely to see her, he left. There is no relationship here. Two wildly diverse situations, and certainly the Ralph Now situation does not speak of ambivalence. That cannot be used as an analogy of ambivalence at all. But what struck me about that aspect of the doctor's testimony wasn't even so much that he got the facts all wrong of the Ralph Now incident, but that he told that story to the defendant. And he proffered it as an exculpatory explanation for the defendant's conduct in the course of a forensic clinical examination. What in the world is he doing giving the defendant exculpatory explanations for his conduct during a clinical examination? What reputable forensic psychiatrist does such a thing? When the doctor should have been probing the defendant with questions as to why he thought he failed to attack Rebecca Schaeffer on that occasion, he furnished the defendant instead with answers, something he admittedly did not do with John Hinckley, and something that I would imagine is not proper forensic psychiatric technique. And while he was in the mood for analogies and comparisons, why did he not proffer Hinckley? There was someone whose similarities to the defendant was absolutely striking, yet he never so much as breathed the name Hinckley during the entire 2 days of interview with this defendant. And I'm sure I know why. Not only did he diagnose Hinckley with a much less sensationally impressive disorder, but Hinckley's failure to act as not ascribed to ambivalence by Dr. Dietz, but to insufficient nerve. Now, lack of nerve clearly does nothing good for the defense position in this case, but unfortunately it probably is the only correct explanation that objectively encompasses all the evidence. Also unfortunate is the fact that this explanation was not proffered to Mr. Bardo, along with the ambivalence story, to at least give him a choice and let us see what he endorsed. But if we examine the evidence in its totality, the defendant's lack of nerve becomes the most obviously correct answer to the question of not only why he failed to attack in 1987, but also at least partially why he failed to shoot the first visit in 1989. As described by Dr. Dietz, the defendant's frame of mind concerning Rebecca Schaeffer involved at least equal parts of animosity and hatred, along with the admiration and love, as far back as 1987. According to the defendant's statements to Dr. Dietz on the first day of interview, the animosity first surfaced before he ever went to Burbank Studios in June of 1987, when he indicated that in May, he read an article in TV Guide that made her sound arrogant, and he felt animosity for her. Now, after the first visit that he paid to Burbank Studios in June of 1987, when he got thrown off the lot, that animosity grew substantially, so that after meeting Jack Egger and being tossed off the lot of Burbank Studios, the defendant harbored tremendous hostility against Rebecca Schaeffer. It is certainly interesting to note that while the defendant was seated in Jack Egger's office in June of 1987, and Jack Egger thought the defendant presented himself as calm, rational, and unusually understanding of the hopelessness of his pursuit, all the while, we now learn the defendant was seething inside at his failure to achieve his goal of meeting Rebecca Schaeffer. Even more interesting is the fact that the defendant was so willing to attribute the rebuff to Rebecca Schaeffer rather than the guards or Jack Egger. Why, if he was so in love with this girl, did he not absolve Rebecca Schaeffer of the blame and curse those evil security personnel? What this shows, rather than love of Rebecca Schaeffer, Your Honor, is that the defendant has a remarkable willingness to hate and to seek out what he was searching for as a way to rationalize his hatred and a way to justify himself and justify his desire to commit murder. And so he found it in what he chose to perceive was her rejection of him and her supposedly impending loss of innocence. Although he did not do so during direct examination, on cross-examination, Dr. Dietz admitted that his research revealed that an important motivating factor for celebrity stalkers was their quest for quick and easy fame. He attempted to downplay that motivation for the defendant, but even he, when pressed, was forced to admit that this defendant's desire for fame and identification with celebrity stalkers long preceded his obsession with Rebecca Schaeffer. Indeed, the one obsession that predates his fascination with Rebecca Schaeffer and fairly permeates his writings from 1984 to the present is his obsession with fame. And it is that tremendous desire for fame and notoriety that lies at the real core of this case and describes this defendant's true motivation. It provides the one answer that truly explains and logically connects all of his conduct. For in his persistent pursuit of a celebrity whom he admits probably never even knew about him, the defendant relentlessly pursued the rejection that he himself knew would certainly ensue. And so in a sense, it would never have mattered how nice or how mean Rebecca Schaeffer behaved toward him, because at some point, she was sure to either ignore him, forget him, or take steps to have him removed from her life. And at that point, he would have found the justification to do exactly what he has done. If there's any doubt about this, Your Honor, I refer the court to that portion of the videotape in the second half of the interview, when Dr. Dietz asked the defendant how he would have responded if Rebecca Schaeffer had secured a temporary restraining order against him. The defendant stated, and I quote, "I'd have been upset with her, and I'd probably have resorted to violence first. It would upset me, seem like she's a snotty little bitch. And I'd say, fuck you, I'm going to get after you now, and I'd have got you at a time when you did not even expect it, because I'd take that as an offense." When this obvious desire for fame is understood as defendant's true motivation, many things become clear that are otherwise inexplicable. And at this point now, I refer to his letter to Arlene. Now, that letter was certain to incriminate him, no matter how far he ran once the murder was committed. That letter assured him that he would be apprehended and so recognized for his deed. In this light also, we can understand why he wrote to newspaper reporters and a television evangelist who reads letters on television. I'm referring now, Your Honor, to Morris Cirillo. The same desire for fame, not, as Dr. Dietz would have us believe, Your Honor, because he's more solicitous of Rebecca Schaeffer's image than his own welfare. Not at all. As a matter of fact, I'm hard-pressed to understand how that letter to evangelist Morris Cirillo can be considered in any way to be favorable to Rebecca Schaeffer. And I read to you the following passage from this exhibit, the letter to Morris Cirillo. And I'm quoting, I wonder if I should feel guilt over amoral fornicator Rebecca or not care at all and feel justified at presenting my own brand of moral justice. How in the world is that protective of her innocent image? In light of what the evidence shows, Dr. Dietz's explanation makes no sense at all. But when one views the evidence from the perspective of a defendant motivated chiefly by a desire for fame, it all falls into place. And so although the defendant found some cause for animosity before the first visit to Burbank Studios, he most certainly found all he could have hoped for in that eviction from the studios in June of 1987. And with every letter he wrote to which he got no response, the defendant found more cause to hate and thus more basis on which to rationalize his means to acquire fame. And one other point should be brought out in this vein. It appears rather clearly that for all the love this defendant supposedly had for Rebecca Schaeffer, every visit to Los Angeles seemed to have been impelled by animosity. The first visit was immediately preceded by his reading of a TV Guide interview with Rebecca Schaeffer that the defendant felt made her sound arrogant. The second visit in July of 1987 was impelled by the disastrous first visit to the studios, and that's the visit where he came armed with a knife prepared to kill her. The third visit was immediately preceded by a TV Guide interview in which Rebecca Schaeffer mentioned her boyfriend, which the defendant thought made her sound like a quote-unquote fucking whore. The final visit, we know, was motivated by the desire to commit murder. So I don't know what, if any, actions the defendant took as a result of his great love that the doctor described, but it's clear that what motivated his physical approach was animosity and hatred, and not love. Dr. Dietz spoke of the toggle switch on this defendant's emotions, causing him to swing rapidly from love to hate. But this is very interesting. I don't understand what happened to that toggle switch from June to July of 1987. It got stuck. The defendant said that in July he still had a lot of animosity for Rebecca Schaeffer, and so he came armed with a knife to do to her what Jackson did to Teresa Saldana. I can't find any evidence of ambivalence in that statement. And while it's true that he did not attack Rebecca Schaeffer at that particular time, there are many reasons that can explain that other than ambivalence, not the least of which is lack of nerve or a realistically based assessment that his chances of success were nil. The thing about this ambivalence story, Your Honor, and the story of vacillation is that it finds no mention in any pre-offense statement by this defendant. And he made many pre-offense statements. The court has reviewed them. His letters to Rebecca Schaeffer, the letter to Arlene, the letter to Bono, and we have a copy of the letter to Arlene that is even less cryptic than the one he actually gave to her. The Nudity Two Shoes poem. His admission of the letters he wrote threatening to murder Rebecca Schaeffer that he never sent. Where's the ambivalence, Your Honor? I don't see the ambivalence. If the ambivalence was something that existed on the date of the murder, then why is it that within days, within weeks of that murder, prior to the murder, we see none of it? Why is that? For a while, through 1988, the defendant indicated that he forgot about Rebecca Schaeffer, perhaps because he realized that she was not as accessible as he thought. But then after he found Debbie Gibson and Tiffany to be at least as inaccessible as Rebecca Schaeffer, he returned to Rebecca Schaeffer. Now, the defendant told Dr. Dietz that he began to think of Rebecca Schaeffer again when he saw the ad for Scenes from a Class Struggle in Beverly Hills. The court will recall that testimony. But I don't think so. I think a more obvious explanation for the defendant's renewed interest in her lies in the article he read in People magazine about how Arthur Jackson found Teresa Saldana by using a private investigator. And I believe that article was testified that he had read that in May of 1989. And that explanation makes even more sense when one remembers that he wrote the letter to Arlene before he saw the movie, Scenes from a Class Struggle in Beverly Hills. Indeed, the letter to Arlene makes no mention of vengeance taken for an idol's loss of integrity, Your Honor. I think it's noteworthy in that respect. It only speaks of the desire to be rid of an unattainable obsession. So the defendant's discovery of the means to carry out his plan is much more in keeping with the evidence than this idea about he saw the ad for the Scenes from the Class Struggle and decided he had to stop this impending loss of innocence. I don't buy it. And with that discovery, the defendant realized, after reading the People magazine article, that he now had the means to carry out his plan, this time without being detected or thrown out by security guards. Again, I noted that he told Dr. Dietz he still had animosity for Rebecca Schaeffer when he thought of her again in 1989. Again, that toggle switch seems to have gotten stuck. The doctor told us of how the defendant said he wrote numerous letters threatening to kill Rebecca Schaeffer. Remember the testimony where he indicated that he wrote letters repeatedly saying, "I'm going to kill you, bitch." But he told Dr. Dietz he was very cautious not to send those letters because he would be afraid then that she would notify the police. I don't see anything ambivalent about that. The defendant talked his brother into buying him a gun. I don't see anything ambivalent about that. He went and purchased special ammunition. I don't see anything ambivalent about that. The gun expert testified that, from what he could tell, there had been a substantial amount of target practice, which, when we put it together with Edward Bardo's testimony, would indicate that the defendant did substantial target practice on the day he left for Los Angeles with that gun. I don't see anything ambivalent in that. And he wrote the letter to his sister Arlene. Now, try as I might, Your Honor, I simply could not detect any ambivalence in that letter, nor, when pressed, could Dr. Dietz. That letter, left virtually unexplored by Dr. Dietz, evinces a firm, consistent, and unwavering determination to commit murder. Nowhere in the doctor's testimony did I find that he attempted to question the defendant about that letter in any depth at all. Oh, he danced around the edges, and he asked him what the mission was, as he referred to it in the letter. But at no time did he confront the defendant with its clear import and ask for an explanation of what it meant. At no time did he question the defendant's assertions of uncertainty about what would happen by simply pointing to the letter and asking the defendant to show the uncertainty in those words. And the simple answer to that question would have been, there is no uncertainty. And that letter is the only truthful statement we have from this defendant about what he meant to do. No psychiatrist stood at his elbow to tell him stories of ambivalence, and no judge or prosecutor loomed in front of him to warn him of punishment. For that one time, that one moment, Your Honor, the defendant spoke his own mind, unaided and unafraid. And the words he spoke described a plan of cold and calculated murder. These were the words Dr. Dietz might also have heard from Dr. Stahlberg, if he'd been so inclined. I find no good or valid explanation for his failure to call Dr. Stahlberg. If the defendant told Dr. Stahlberg he'd been thinking of killing Rebecca Schaeffer when he went back the second time, then an impartial expert would want and need to know about that. And if he in fact lied to Dr. Stahlberg, then an impartial expert would certainly want to know about that. And when a defendant tells an impartial psychiatrist that he may have lied to yet another psychiatrist and lied to two police agencies and then possibly lied.
I don't think Marcia knows the definition of the word brief. Because this isn't brief. Come on, Marcia. Wrap it up. What time is it? Okay, we got like 50 minutes.
Lied about why he lied to these people. An impartial psychiatrist would not only want to know about it, but would be very skeptical of any uncorroborated self-serving statements the defendant made to him. Yet Dr. Dietz did none of those things. And he compounded his egregious inaction with respect to Dr. Stahlberg by relying on the defendant's self-serving statements for which not only is there no corroboration, but there's actually directly contradictory evidence. The defendant told of his phone call to Arlene and said himself that he had not yet worked up the nerve. And if he had, he said, I wasn't sure if I had the nerve. And if we had any doubt about what he meant by that, he went on to say, it's one thing to fantasize about violence, but it's another thing to do violence. So when he went to Rebecca Schaeffer's door, he was not ready mentally to do what he'd planned, nor was he physically ready, having left one chamber in the gun empty. And when she unexpectedly came to the door, he was thoroughly nonplussed after expecting to only talk to her through the intercom. Now, this first visit that Dr. Dietz believes the defendant came away from feeling so joyous appears not to have been so wonderful when we fairly examine the defendant's rendition. The defendant stated she was behaving cautiously, moving the door back and forth. She gave him a cold look. She looked at him suspiciously. She told him, I'd rather you not come back to my front door. She acted like she was in a hurry to get back inside. In fact, all of the things based on the defendant's previous statements that he would have found as evidence of her arrogance. There it was. All of the things that he talked about that would have indicated to him she was an arrogant bitch and she needed killing. She did it in that first visit, according to the defendant's rendition of that visit. Rather than confront the defendant with these contradictions, to probe for his true state of mind when he returned the second time, the doctor passively accepted his characterization of the first visit as friendly and his mental state as joyous. It seems obvious that a defendant, Your Honor, who has admittedly lied before and at this late date clearly knows what he's up against and needs to lie about, and also knows that if the first visit went badly, there is no innocent explanation for going back, particularly given his previous statement about his plans for Rebecca Schaeffer, should be very seriously questioned and probed as to the veracity of these assertions that cannot be corroborated. And Dr. Dietz simply failed to do so, and failed miserably. This is a point particularly, if you unravel all of it, if you come right down to it, you can question everything. But what it really comes down to are two salient points. The defendant's assertion that the first visit left him joyous and it went well, and the defendant's assertion that he returned the second time for the purpose of a pleasant encounter and not to kill her. Those 2 points bore very careful scrutiny, especially in view of this defendant's previous statements and in light of the evidence in this case, as I pointed out. But Dr. Dietz did nothing to test the veracity of this story, even riddled as it was with contradictions and motives to fabricate. Now, the defendant stated that after the first visit, he retreated and he loaded the one empty chamber left in the gun. Now, given, Your Honor, the letter he wrote to his sister, the statement he made to his niece in which he said, "I'm going to put Rebecca to sleep," the package that he carried with him that Dr. Dietz admitted sounded like an assassin's kit, in addition to all the other evidence of this defendant's avowed desire to kill Rebecca Schaeffer, one would think that a certain amount of confrontation and inquiry would take place at the point when the defendant admits to filling the empty chamber before going back to Rebecca Schaeffer's apartment. But no. When I posed to Dr. Dietz all the logical contradictions that refuted the defendant's story about why he went back the second time and loaded up the empty chamber before he did so, and asked if he'd pointed those out to the defendant, he replied that he had not. Not only no, and here's why, or, well, we didn't have the time, just no, I didn't. Again, I can think of no valid explanation for his failure to do so, and this goes to the very heart of his diagnosis and the core of the case. If one does not probe the reason the defendant gave for his very damning action, then how can a valid conclusion be reached? The answer is that no valid conclusion is likely to be obtained in the passive, non-confrontational method used here. If this defendant can concoct exculpatory excuses to rationalize incriminating evidence, then he is clearly high-functioning enough and sophisticated enough to be confronted with the illogic of his stories and pressed for a more truthful explanation. But that was never done here by Dr. Dietz. And then, when the defendant returned the second time and claimed to have had this conversation with Rebecca Schaeffer, the doctor, for no discernibly good reason, rejected the testimony of the percipient witness, Lynn Marta, in favor of the defendant's self-serving statement. Now, the defense attacks the statement given by Lynn Marta on the grounds that the investigator who went out to the crime scene could hear the latch being opened and the window in the door reverberate on every occasion that the door was opened. And he indicated that as audible as those sounds were, equally audible were the sounds of voices, which the investigator indicated he could hear on every occasion. That he heard the female's voice inside, clearly heard the words, heard everything the female said inside, and heard the, I believe Mr. Galindo played the part of Mr. Bardo standing outside, could at least hear him mumbling, and on 2 of the 3 occasions actually heard him speaking, even standing outside the door. So Lynn Marta's testimony that conversations were easily audible from where she stood inside her apartment is clearly corroborated, completely corroborated. But the defense would point to the fact that she failed to hear the latch, and thus she would have also failed to hear the voices because the 2 were equally audible. Well, it kind of sounds like inductive reasoning, but even leaving that to one side, look at this logically, Your Honor. She hears Rebecca Schaeffer's buzzer. She hears Rebecca Schaeffer walk down the hallway, and then a sound that she must hear 10 times a day if she hears it once, every day of her life that she's in that apartment, is going to occur. the latch is going to open and the door is going to move. When you hear a sound every day, repeatedly, you either stop recognizing that sound and stop paying attention to it, or you become extremely agitated. Like a person who lives in the flight path of airplanes. That person, after a while, they don't hear them anymore. If you've ever asked a person who lives in that kind of situation, what plane? What plane? They're not crazy. They've adapted, of course, and you have to. And so did Lynn Marta. Now, conversation, that's a different story. When she hears Rebecca talking at the doorway, that's going to be something that will grab her attention, because after all, she was thinking about talking to Rebecca Schaeffer.
Travis and I, before we got married, but we were engaged, and I used to go to his house. He lived near train tracks. And one night, train woke me up in the middle of the night. And I sat up straight, and I was like, where in the heck is that coming from? I'm like, Travis. What? How can you sleep through that? Through what? The train. What train? She is exactly right. I was like, the train, Travis. Oh, yeah. There's a train. Back to sleep.
And explaining why the newspaper was thrown away. So far from demonstrating that Lynn Marta's testimony is suspect, the experiment demonstrated that now we have absolutely no lingering doubt and no cause to suspect that she was anything other than completely correct when she states that there was no conversation. Now, when the defendant stated that there was a conversation, he indicates many different statements said by Rebecca Schaeffer. I'm going to get into this in a moment when we play the tape, because I think it's very interesting, the change in demeanor when we see him attempt to recreate that portion of the events on the date of July 18th, 1989. But in asking Dr. Dietz why it was that when posed with a direct conflict like that between the statement of an admitted liar who is now facing a very serious charge, who is giving a self-serving exculpatory statement, why he chose instead to believe that over the statement of a witness whom he never interviewed, never went to the crime scene, never examined any of the evidence pertaining to the audible nature of the voices within her apartment. He never did a thing to examine the truth of her testimony. He simply rejected it. And what's interesting was that he gave the reason he actually stated, I believe it was on direct examination, I could be wrong about that, but I think the reason that he gave at some point was the scientific data he attempted to rely upon, and it was totally inept. He claimed that witnesses to traumatic events suffer a perceptual distortion of time. But those studies revealed that the distortion dealt with dilation, not contraction. And so if Ms. Marta's perceptions were so distorted, as he's indicated, according to those studies, then the defendant acted even faster than she thought he did, which clearly renders the doctor's conclusion even weaker. But at no point did he really address the fact that she heard no conversation at all before the shot. And how did he manage to reject that testimony without ever laying eyes on her or the crime scene? I have no idea. And he never gave any plausible or acceptable reason for that inexplicable rejection of such important evidence. And again, he also failed to confront the defendant with this glaring contradiction, and I sure would have liked to have heard the answer. It would have been very illuminating, I think, for all of us to have heard what the defendant had to say in the course of the clinical interview about this contradictory evidence, but that never happened. Now, there's another final glaring contradiction that was never probed by Dr. Dietz. When the defendant attempted to reenact his movements in the moments before the murder, he did a few things that struck my attention. First of all, although his rendition of the conversation at the first visit was clear and concise, his rendition of the second conversation at the second visit was uncharacteristically hazy and confused. And I found that very interesting, and I attempted to probe that with Dr. Dietz, because that in itself might give you some clue that it is a fabrication. If he himself all of a sudden is stumbling, well, I can't really remember this part. Oh, well, it was mumbled. Oh, well, it wasn't clear. When everything else was crystal clear, and all previous statements given were very definite, very concise, and very consistently repeated, then you have some indication that there may be reason to doubt the veracity of the statements made about that second visit. And the doctor failed to do so. As a matter of fact, he guessed at her words and he stumbled with his alleged memory of the conversation. Second of all, he described fumbling with the bag held in front of his body, and he verbalized drawing the gun out of the bag. But even as he was saying that, Your Honor, he reached behind his back for the gun. It's kind of like the physical version of a Freudian slip. When the defendant, he was in the moment and he was reliving the crime, his body unconsciously did what really happened, while his mouth spoke the contradictory words of the fabrication he was attempting to put over. And I'd like to play the tape now so the court can review this portion with these thoughts in mind.
Not the whole thing.
No, just
She's been recognizing I went into the phone with my day, and during the time I was looking at it, she looked close, the skin on her forehead is kind of, she's constantly looking down like this, her skin was like auburn, it was kind of auburn, instead of just being pale skin, like her hair, and she's just constantly looking, I guess, is wet or hot, water dripping down the right side. And I think I saw her wearing a necklace or something. She seemed so uncommon. She seemed kind of, that she was being disturbed again. So I thought she sensation, which is at the wrong time. It's nerve. The gun is in bed like this, And at the bottom of the things, wrapped around the barrel of the gun, and that this grocery bag is kind of hard for the chain, right? I was like, from the rock and ready, And she says, I think she, I wasn't very, I couldn't, I wasn't focusing too much attention on her, but it seemed like she said, you need to come to my house, give me a litter, again, Like she was like I was bothering her, and I thought, that was such an statement, And I was a little nervous, And then she says, she says, just, she saw what she's saying, hurry up, don't let her. She's really wasting my time. She's mumbling. She sounded like a little kid, She sounded like a little. She has a kid, like a kid voice, like she sounded like a little brat or something. She's wasting her time, like I mean, I thought that was very common to say to a fan, I must say,
See what I mean, Your Honor? Even when he means to be reaching in front of the bag, in front of his body, he reaches back behind him again. Twice. That's too much for coincidence, Your Honor. If we consider that for a moment, that when he went back the second time, he actually had the gun in the back of his waistband with his shirt pulled over it, the defendant's true intention in returning a second time becomes even more crystal clear than it has been. Putting it all together, he loaded the empty chamber, put the gun in his waistband, went to the door, rang the buzzer, stepped back and waited until Rebecca Schaeffer came out onto the porch, stepped up when she came out, grabbed her arm, grabbed his gun from behind him, and fired. And had Dr. Dietz taken the trouble to explore these possibilities with the defendant, he would have noticed that the shirt the defendant wore at the time of the murder had blood spatters on the shirt tails, a fact that would cause a reasonable, objective mind to at least explore the possibility that the defendant's actions spoke louder than his contradictory, exculpatory words, and that those actions described a premeditated murder committed by means of lying in wait. But again, Dr. Dietz failed to do that. And what we're left with in Dr. Dietz is a well-credentialed man who inexplicably accepted a defendant's uncorroborated, self-serving statements as the basis of his opinion in this case. As such, his conclusions are worth as much weight as this court would give to any defendant's uncorroborated exculpatory statement that is not only self-contradictory in logic, but is refuted by the evidence. And so we are left with the evidence in this case. And the evidence remains untouched and uncontradicted, exactly as it stood when the prosecution rested its case in chief, except slightly better, because now there can be no lingering doubt about this defendant's mental state at the time of the murder. The evidence stands as conclusive proof that the defendant murdered Rebecca Schaeffer in cold blood by means of lying in wait. Thank you, Ron.
15 minutes, ladies and gentlemen.
What time is it? Oh, are we gonna finish this today?
Analysis and reanalysis, reading and rereading. And let me analyze a little bit. Let me share a little bit with you my analysis. If you look at this case from the standpoint of the physical facts and the physical facts alone, I think it is very clear that this is a killing by lying in wait. We have a young lady who answers the door to her apartment house. The comm doesn't work. She goes to the apartment door and she is shot. The circumstances, as testified by Ms. Marta, are that she heard a buzzer. That's her testimony now. At the preliminary hearing, she said she wasn't sure, but she thought she had. And that she heard the victim leave her apartment, walk past her apartment, that she paralleled her walk, that she walked to the front door of the apartment house, that very, very shortly after she heard the last step, she said a second or a split second. The preliminary hearing was a second or a second and a half, something of that nature. There was a shot. Clearly not enough time for any conversation to occur. It implies that somebody rang the bell for the purpose of luring her out of her apartment so that she could be killed. You can talk about Ms. Marta and her focusing on a cat. I really don't think that that would distract someone from hearing voices. The experiment conducted Friday shows that the voices were clearly audible, even the content of the person who was inside the apartment house. You have a lady who testified she's in the habit of sometimes listening to the actual conversations. This is a new event. It's not an expected event. It's not something that she hears day in and day out, as Ms. Clark pointed out. It is an unexpected event that would grab the attention. There is no doubt in my mind she would know if a conversation occurred at that doorway. Further, if you look at the conversation, listen to it, as reported by Mr. Bardo, and don't get me wrong, I am in no way accepting his statement for the truth of the matter asserted. I have repeatedly stated to both sides that these statements are going to be received only as a basis for the psychiatrist's opinion and not for the truth of the matter asserted. I am not a jury. I do not confuse the law and legal principles. On the other hand, they should be given a great deal of consideration because they did form a large part of the psychiatrist's opinion, a large part of the basis for his opinion, and I'll get back to that a little later. You have the incontrovertible fact that Rebecca Schaeffer was killed by a bullet that went in at an extreme angle to the horizontal. You can talk about any doubt you may have. I doubt the doctor's statement of 75 degrees, but it's as good as any. If you look at the autopsy photographs in which the welding rod has been inserted into the wound, it makes a very, very clear sharp angle to the horizontal. It's somewhere around 75 degrees. We have the fact that her feet are outside the door. I mentioned in my examination of Dr. Dietz whether he had considered this fact, the fact that her feet were still outside the door, despite the fact that she was shot in the chest by a very high-powered slug, which would have probably thrown her back, but certainly wouldn't pull her forward. She was found in that position. That evidence is uncontroverted, which means that she went outside that door. Analyzing now, without excluding the defense evidence, but analyzing it just from the prosecution's standpoint, that she would go out to have a conversation, dressed as she was, with a man that had made a visit previously, who was just a fan, a man of what Dr. Dietz calls odd appearance. Isn't that really believable? Analyzing the people's evidence, there's no doubt in my mind, according to that evidence, that Ms. Schaeffer went to the door, saw no one, opened the door, perhaps when we don't know why she was bent over, but we know that she was bent over. The kind of angle that this shot made would have to be either by a gun that's held above her head, pointing almost straight down, or she would have to be in a position where a reasonably level shot would make that kind of a hole. All this speaks incontrovertibly of lying in wait. When you add to that I saw the doctors, in fact, I examined them on this, whether shocking events dilate or contract time. It's what I think is reasonably apparent is that they do not erase simultaneity of events. And what Ms. Marta experienced was a shot following almost immediately upon the last footfall. We know from the experiment Friday that the area just before the door makes no sounds when people walk on it. All that does is give her time to get to the door and open it. All right, those are the hard facts. Let's see what impact the psychiatric testimony has on them. In the first place, as I said, and I'll say it again for the umpteenth time, nothing the defendant said to the psychiatrist is admissible for the truth of the matter stated in his statement. And of course, there's a reason for that. As we know, it's hearsay. And there are basically three reasons why hearsay is not admissible unless it's subject to an exception to the hearsay rule. Number one, it's not made on oath, under oath, and I give that very little weight in this case. Number two, you cannot observe the demeanor of the defendant. Well, we can observe his demeanor at least on the tape. So that has less weight. But what impresses me about this interview that we saw. Obviously, the letters he wrote, the statements he gave to the police, those are all not susceptible of cross-examination. Police officers don't cross-examine people very often because they stop talking and they start demanding the Miranda rights. And while here they had already been claimed by the defendant, prior to the statement, old habits die hard. And I saw no cross-examination of any consequence by the police in the Tucson tape, following it along as well as I could with the transcript. The main reason why hearsay is not admissible is that the person who makes the statement is not subject to cross-examination. The defendant in this case was not challenged by Dr. Dietz in any way. I saw the tape that was not played in open court yesterday, the tape that was admitted in evidence. No challenge, no pointing out of inconsistencies, just asking and accepting whatever the defendant had to say. Now, I said at the time of the denial of the 1118 motion that I was going to have to reanalyze the evidence in this case. It appeared that the defendant made a statement that was somewhat similar to the statement that he wrote in the letter to Mr. Cleaves, and I've done so. And there seems to be some similarity between the statement that he gave to the Los Angeles police and the Tucson police and the Cleaves statement. And that statement is that he went back sort of expecting a pleasant visit.
We know what.
Now, how much weight do you give to that? Number one, I can't accept it flat out as him actually accepting a pleasant visit, except insofar as it affects the psychiatrist's opinion. What I analyzed this with is the fact that the defendant consciously lied to both Tucson and to LAPD as to how the accident happened. Here's a gentleman who is supposed to be extremely schizophrenic, who can concoct a story making the shooting accidental. Now, Dr. Dietz can talk all he wants about the defendant admitting this, admitting that. I didn't see the defendant admit anything that he didn't have to admit by the force of evidence. When he's in jail and he's making these statements to Tucson and LAPD, he knows they've got the right to chat. He expected to be caught. I think to Mr. Bardo, being caught was part of the plan. He said that the door bumped his elbow and the gun went off, and that is totally inconsistent with the facts. And the defendant backed off that at some point, presumably when he found out that it was an absurd statement. Dr. Dietz said, in response to questions by Ms. Clark and in response to questions by myself, that the reason for that was to protect his brother, without once informing us that he didn't even believe that to be the main reason, which he later admitted. The reason for that statement, according to Dr. Dietz, was for Mr. Bardo to protect himself. Was he ever challenged on this by Dr. Dietz? No. Ms. Clark pointed out a number of things that Dr. Dietz did not challenge the defendant on, which is the function, I suppose, of cross-examination. And by the way, let me quote Felix Frankfurter on this. He said that cross-examination is the most effective engine for the discernment of truth ever devised by the human mind. And I believe that. The defendant did not take the stand, and I respect his right not to do so. But when that doesn't happen, we have no evidence as to what occurred except his self-serving statements, and they continue to be self-serving. Mr. Bardo wrote a letter to Mr. Cleves, the last letter that was received in evidence, in which he said he was hoping to get second degree or even less. His motive is apparent, and how much more even now than then. I saw the tape that was introduced of the second part of the conversation with Dr. Dietz, and I not only saw a failure to cross-examine on the part of the doctor, a failure to point out or inquire as to why he put the last bullet
Yeah, I
in
know, Nancy.
the
We're trying to get through
remaining
this.
empty chamber
Almost
between the two
over.
visits, despite the fact that he hadn't put it in when he was in the tough neighborhood. As a matter of fact, when he was in a tough neighborhood, and I think I can take judicial notice of the character of the neighborhood around the bus station in downtown LA. It is one of the most dangerous neighborhoods that I can conceive of, especially on the odd hours. He goes from that tough neighborhood where he could have easily gone into a restroom and loaded the gun entirely to be prepared for any robbery that he thinks might be.
Especially if he asked him, did he form the intent to kill Stahlberg?
About intending to kill at the second visit, imminent
Okay.
upon his exiting from the bus station.
Okay. No. It's too long. We're not going to make it. Well, actually, well. Okay. Let's do Brian Walsh. I'll see you guys over there.